the two different routes that the document can go. But ordinary care and
We
what
know
was it?
that by the way a person is carrying themselves ordinarily in their practice and in their capacity. What do they do? If they do what they do, then they have ordinary care.
Hmm.
There's
Yeah,
other
and then
things that constitutes that, like you making your writing. That's a show and a sign of ordinary care.
absolutely. And then I liked also how too it expanded into like customary banking channels, and that if we make payment, then this document will never make its way into a customary banking channel to do what it does in finance.
And that's what they're mentioning and speaking about in Article 1, where they let you know the scope of a transaction, which is to further commercial transactions, custom, and usage. That custom is this ordinary, customary banking channel, and customs overseas. That's what they're referring to, the actual
Hmm.
transactions of who actually take that, where it's actually happening and how it's
Hmm.
happening at a different place. So that place needs something separate. Separate is always going to be something that you will see mentioned a lot of the time, because whatever it is that this bank need under the states that they are referencing, saying that they'll contact, saying that they'll call, they'll have certain rights as it relates to ordinary care, and they're going to be dealing with types of deposits, or for us more so, they're going to be an intermediary, someone
Yeah.
who is stepping in and seeing to it that the payer bank actually is the bank that deposits for the person who is engaged in business versus you depositing for that person who is engaged in business. And it always happens on present days. Present
Hmm.
times where we are receiving and giving things, especially as it relates to any type of medium of exchange like money. So terms,
Hmm.
units of accounts, things like that.
Yep.
Let's see what this article applies to. The applicability of bank collections and bank deposits. Now, when you just think about bank in itself, you think about, okay, state banks, who Navy Fed, Bank of America, all of them. Then you got to think about federal banks as well, and then you have to think about the definition of banks, as the UCC defined it, being loans associations, credit unions, those who are engaged in the business of banking. How is this applicable
Hmm.
whenever they are deciding to partake in a collection transaction or a deposit transaction?
Hmm.
How do you feel about reading now? How do like when you go off on your own and you're doing things, how you feeling now, or what approach are you taking?
Oh man, that's a good question. Because like I apply that separately as far as like when I'm reading the UCC. Like if I'm listening to one of your recordings and I'm just kind of reading along the UCC as opposed to an agreement, um, I feel like it's harder. It's still harder for me to read an agreement because I'm still trying to translate what's being said, in ambiguous language. But I love referring back to the UCC. I just read this the other day. I was in four reading this very applicability section about how eight governs, and then I don't know. To answer your question though, I feel like I'm always getting better, but I still don't feel like I don't have any kind of mastery with it. But bold and conspicuous, obviously just the core principles, I'm just applying those whatever I'm reading most of the time. So
Okay, good. Because of course, that's what I do. Because here they are going to give you a lot of information, because they're not only talking about things that relates to collections, they're also talking about things that relates to deposits. So a lot of the sections are lengthy,
yeah.
unless it can be operated by the same person in the capacity that is constituting another's
Yeah.
constitution. These are things that maybe not exactly
Mhm.
it, but could be in the form of
Mhm.
it in some ways, has some characteristics, maybe not all the way, but so close to where I can constitute it as this, and or I can treat it as this.
Mhm. Yeah. Yeah, I like how you say it exists, but it's not quite in existence. And when
Right.
you say that, I think of it like it's such a good way to say it, you know. Sure, it's an instrument, but it's not negotiable yet. It has to be. It needs like it needs more. It's got to be
Right.
taken further.
So if anything, according to Article 4 we are right now, see it as an item. See it as something that
Item,
can be
right?
purchased, and then you put yourself in a position to where either you're going to be the one to purchase it, or you're going to think about and step outside of the box to see a way or how another person can purchase it. Because according to Article 4, we understand that this applies to banks, and you have an item of a type because of this article.
Hmm.
What other articles may this item constitutes as something that may apply? Article 3 and 8.
Yeah,
Do you understand how they are given this?
yeah, for sure. Yeah, absolutely. Especially with eight, because you know, when eight starts talking about security and it's an obligation of the issuer, and that's who the protected purchaser is. It's like it all goes back to rights. That's what I'm seeing more and more.
Well,
It's just about rights. It's like who started making this, you know, who began the manufacturing of this, and like the rights is one thing that always it's really bringing me back to center more often now, not getting distracted by payment or transactions even, but just like, all right, what are the rights? Like, what are the rights here? Like, who has the rights here?
exactly. And that's what the point that they're trying to make in A, because they're talking about conflict. So this is what they begin
Yeah,
to ask you: if you believe this, or if it's a mistake, or hey, it should be this and this and this going on electronically by a bank. There's some sort of conflict. And then you should understand that, okay, this item could apply and be governed by 3, but 8 governs. So this is somebody else's property. And before 8, Article 3 can even govern the person who property this actually is, I have to solve something for them. I have to provide some sort of resolution to a problem that they're having so that they can get whatever it is that they want under Article 3, which we already know is a check or a money order.
sure. Yeah, amen to
Another type
that.
of order.
I was just messing around today and I was popping in. I sometimes I just I don't rely on Chat GPT for anything, but I like typed in Google. I was like, can securities be negotiable instruments? And it was like, yeah, absolutely. Like they're almost synonymous at times because of their negotiability. So I thought that was really interesting. And
That also
they,
goes to the reason why it's separated from your account, why it is that perforated line.
yeah.
You understand that that account is not negotiable. What's
Mm,
attached to it, could that be? It could constitute as it if it's in the right place. And that's what Article 4 is about.
mm.
So how you feeling about the first point that they made in A? This is basically what we just covered. They're letting you know how this and when this applies. And Article 4 is something that's going to be in between. It's early on. This is like number 4. So this
Hmm.
is something that they are expecting, and this is something that's in the beginning. This is something that is often used. This is something that is always a part of, which is why it's so close up to the other articles 3, 2, and 1.
Yeah, for sure. Uh, the way that I feel about it is the UCC can it's it's like a it's just this web it's a web and its connections can go like kind of any article to any other article. um but as far as like eight connecting to four, um that's when they talk about eight and they talk about security, and security is an obligation, and then a contract is the total legal obligation. And for there to be like the contract has to be formed from an agreement to be negotiable. It's like everything is like crisscrossing and connecting in some way.
It's uniform. So that means that we're all individual, but
Yeah.
we could be the same. Or better yet, we can come together, we can group together. But even when we group together, we are all individual. We still all could break apart.
Mm.
And
Yeah,
when we break apart, we're still in the same element, but just not in the same place. I'm doing
definitely.
something different. My function is different. But if me and another come together who's uniform with, the principles, then we can come together and 4 can go to 8 and 3 could go with 1 and things like that.
Yeah, definitely. Absolutely. But what
Liability.
my I guess my what I was trying to say simply was just that though it is an order, there is also just kind of like they're stating right now that 8 governs 3, 9 governs 3, or there can be if there is
And
conflict,
five. Yeah.
they give the rules so it can bounce around a little bit. It was a little hard to keep up with, but I think as I go on, I'm getting a little more proficient in kind of seeing that, well, you have to pay respects to 8 before you can look at 3, obviously. Like that should be like an obvious, even for like someone who
Because
has
these
like
are
this.
articles that help provide that protection.
Yes, absolutely.
The
Yeah,
UCC is set up for two purposes: to help performance and to help with enforcement. That's,
hmm
this is enforcement and performances as it relates to banks and their actions dealing with different types of items, different types of forms, different types of property, different types of collateral, things that could be priced.
Yep.
So it's order, but they're able to choose this article,
Yeah,
that
for
article,
sure.
to create
Yeah.
creation.
That's like, yeah, and it for me it's like if I think of item, I have to think of value, and that's why I I think just recently I've realized that why the contract is so important, because it's just like the first time you went to go get real property or personal property, like you wanted a car, house, a card, whatever. It had a finite value. You applied for it, and then because the value was given, then there was an exchange. But and when it comes back to a bill, for example, and the value isn't really set, the value isn't set until the contract is completed and formed. That's what allows there to be a negotiability, because until
But
then
there's no
there's no
value
value.
until
There's
it's
no
tested
value.
for
Right.
value.
There's no value. So like without a contract, there's no value, and or there's a value that's uncertain, and that
Right.
can't be negotiated. That can't be documented, and it can't be recorded, and it can't have any kind of.
It's valuable until the present time, and
And that's
that's
a
where
simple.
Article 4 come in.
Yeah, and that's like it's it's not simple, but it's simple now, I guess. I don't
I feel how you feel. Look, I know what you mean. It's like the more you know, then that's when you can be like, oh, okay. And then you can kind of see other things a little bit more clear,
Yeah.
especially as it relates to the liability. This is where your pressure begins to come off and stay off. Like, remember,
It,
you see it. The liability, it ain't on you, it's of a bank. I've been telling you and telling everybody you are an individual. You shouldn't feel no certain liability when it comes to investment property that you know you when you got an investment, any type of investment property.
yeah. You got property though. That's why I think that's why it might be a little confusing maybe for some folks, but it's
That
weird. They put it.
investment part, you're not an investor, you're not the
No, no.
solicitor, you're not the business, so it
Uh-uh.
can't even could you constitute as a business if you being dealt with in business?
Yeah, no, but it's we get thrown in the mix because it's the ancillary property right that we have to it. It's an interesting.
Device.
Yeah, they
It's
put us in the mix for
It's
sure.
auxiliary for sure, but it's a device, it's a tool, it's an
Yeah,
instrument.
it's rights. It's just rights. It's so
And a
crazy.
person who's supposed to use that tool, who's supposed to create and make things out of that tool, that liability is of a bank.
Yeah, absolutely.
That's what they're making clear as the subject. Is the liability of a bank as it relates to action, is the liability of a bank as it relates to non-action.
hmm
It's not the liability of individuals, not the liability of Corey, it's not the liability of Kamaya. Not
hmm
for anything as it relates to articles that govern. I'm not governed by an article.
Right.
The state is. So dealing with state banks, those who are dealing with cash or dealing with taking any form of cash going in or out, they are considered a bank. The liability of Article 3, negotiable instruments, investment properties, Article 4, that's the liability of them. They got conflict because there's 3 articles at the time that could apply and constitute, but may not be applying all the way. It's subject to
Yeah, for
the
sure.
articles, but those are the articles haven't at that time that need to be tapped into.
Yeah, this was wild because I was just reading in Article 8 today, and like this to me this ties up to adverse claim
And
because it's about
arbitration clauses and why they got
yeah,
the
absolutely.
why they got the
Right,
dispute.
right, exactly. Exactly. That's what we talked about last time is that some agreements they don't really have a they might not have an actual security interest mentioned, but by mentioning a claim, it might as well have because it's
Mm-hmm.
what that's what they're saying. So when I see like the
It gives
claim,
you protection. Even
hmm
saying the word legal,
yeah.
even law, especially when you put governing in front of it. They have sections that are bold for governing law, and then they have sections that's just conspicuous for law. So to keep yourself reminded and keep yourself out of the picture, even though you're going to be receiving these items that belongs to somebody else, that could be made to something different, it's the liability of a bank to do so.
And you think they made mention of that liability governed by the law of the place. That's because that's where the filings have been. That's where the filings have
And the
been
designated
made.
recipients and the debtors and the creditors, they are all under
Right.
the states or have they business filings and dealings under that state.
Yeah. Yeah. Yep.
So the liability of a bank for action or the liability of a bank for non-action is with respect. You always have to show respect to the item. You're not going to disregard it. You're going to always show respect to it. And how you, as an individual, show respect to the item is by responding. If you don't say anything, then you took no action. You
Yep.
can't, you're going to be held liable. But
Yep.
if you show respect to the item and you respond and you're taking the action, stop trying to take the bank's action, but literally take the action of responding. That's showing respect to receiving a package that ain't yours.
hmm
You received a package that's somebody else's. So you want to respond to that. And if you do, then the banks are liable. They're liable for how the item is handled. Who the hell sent it to you? In this way. Or why is it created this way? Different than Article 3. So
Yeah.
action and those type of things are for banks. So an item that is handled by banks for purposes of presentment, purposes of payment, which you slap right there in the middle. Purposes for collection. So 3 different purposes. Someone's collecting, someone's using payments, somebody using presentments, and that's causing conflict. They don't
hmm
know which article applies at one time or what is the subject. What is subject to?
hmm
What is the item subject to? They have no clue. At this present time, it could be subject to other things as it relates to the bank liability,
Yeah.
but it's governed by the law and the place of the law where the bank is actually located. So all of these different locations and addresses is very important. Those are partaken in collection, payment, and presentment. They give you a lot of payment detail information just in case you want to respond. They treat it as a presentment. It constitutes asset and it allows for other articles like 8 and 3 to govern. Without it, can't be any action under those articles. So what you have is a negotiable instrument. What you have is an investment property, but it is the property because you have something that constitutes as a security attached to your account.
hmm
But law matters, not legal matters. Law matters.
hmm hmm
In the case of action, law matters. In the case of non-action, law matters. At a branch or a separate office of a bank, law matters. That bank liability is as it relates to the law. Its liabilities is governed by the law, and is the law the place where the branch or a separate office is located. So whenever you receive that payment, they always give you separate offices and other branches of theirs for presentment.
hmm
It's up to you to be responsible to see to it that that separate office gets it. And if they don't get items, not one but two, then how could they be liable or show respect to the item that you got that was handled wrong, improper? How would they know? Business is between you and another who's governed by a whole different other set of articles, like 1 and 2, where you created a cell.
Yep.
How you feeling? What's your thoughts? Do you understand what this applies and why it's so important? You
Yeah, no,
is so
absolutely.
important.
I guess what it has me thinking, as far as like liability goes,
Mhm.
um, I think that the debtor has its own, maybe not liability, but responsibilities or their own duties. The secured party has their own liability as well. Like whoever they have the security interest in the document already to begin with.
Mhm.
So there's like I think there's different liabilities depending on the party, but regardless, when the termination happens, the liability goes defaults back to the secured party for
Those
them to.
who canceled the contract, those who did not abide by the contract, because
Right,
if you read
exactly.
it, it asks for checks. If you read it, it's dealing with a type of property, whether it's a house, car, credit card. You don't have to say securities. If it's dealing with a property, Article 8 can apply. If later on
Yeah.
in the future it could bring them a check, Article 3 could apply.
Yep.
So it constitutes. So I understand when people say it's a check, it's a negotiable instrument. I understand that. But that's what keeps them stuck.
Yeah. No.
Understanding of that versus the understanding of that. And this is why they struggle with, what do I need to send in? What is the items? What do I got to use? That's why they struggle with the items.
Yeah.
Knowing what applies and who it applies to is important. So questions and inquiries are always made to initiate these actions. Actions that
Definitely.
people want to take so freaking bad. But anytime you see a word like action in the middle like this, without being bold or conspicuous or anything like that, you must refer back to Article 1.
Yep.
So what action mean? You plug it in. The liability of a bank is for action in the sense of a judicial or other meanings, including set off, recoupment, or other proceedings where rights are determined. Bank
Yep.
is liable for that. So you take action in a sense where you are showing respect to an item, not trying
Hmm.
to step on their toes and handle business that they handle. You just understand that it may have just been mishandled.
Yeah. Still determining rights, preceding your own insolvency.
And those rights is what's going to provide remedy for the bank so that they can take action and not just collect but deposit. It's an or right here. This is a decision
Yes.
made. Collection was a decision made. Period. Happening. Boom. Deposit is something that could replace it. And that's governed by law at another place, a separate place, a different place than the place and the person who sent you that statement. This is why they're not
Mhm.
liable. So,
Right. Under the state.
so if you're trying to impose liability on them, there are some consequences. This is why you have people accounts being closed and things like that, because they're like, I didn't do anything. I handled this according to what was applicable at the time and what was governing the intent or the extent of what you're sending is causing more conflict. It's
Yeah.
important to understand that things are going to be different.
Yep.
The price of it, the measurement of it, the amount of it as it relates to damages for it, for the item, it's going to be different. It's always by agreement. That's why reading the agreement and getting the agreement is so important, because that's when you'll begin to see that, okay, checks are important. Article 3 is important. It's important because by that agreement, that's something that they could get. That's something that they look forward to. Right along with measuring an amount of credit, something that constitutes an action for ordinary care. So for as long as they do this, then they can be credited for that.
Hmm.
How do you feel? Do you understand what this section is speaking about and the rights that it gives banks as it relates to different responsibilities? Something that you're going to be aligning with if you want to take an action in the sense that constitutes ordinary care.
Well, definitely. It's super relevant because they're speaking to well the proceeds that they could be foregoing if
Yeah.
if they're not exercising their rights. So that's kind of how I look at this particular section, the measure of the damages, unperformed balances or whatever, however you want to refer to it. But
The
that's what
responsibility
we're concerned about.
But the responsibility and the underlying purpose as it relates to state and federal law, this is when it begins to get a little bit more real, because real banks are handling this. But there are banks under the state acting like banks. They're not banks.
Yeah.
It's a measure. It's a standard of
Standard
things that
practice,
happen
right?
in state and things that happen with feds, and their responsibilities are a little bit more different. So you have a choice. Who responsibilities would you like to align with? It's going to constitute your ordinary care no matter which way you go. Whether you decide to stay under the state and pay with a check yourself or another item like a FRN or anything like that, or if you want to deal with the responsibilities with a federal person.
Yeah.
Federal bank, sometimes who deal with customary banking channels, clearinghouse rules,
Yep.
ACH agreements.
Yep.
So this
Federal Reserve.
is very important to determining the difference. And really, for me, determining the importance of why it's so important to define words. Because if you say payment, but you don't define what payment means, I'm having conflict because I'm having a hard time determining what payment is.
Precisely.
That's the problem. That's conflict.
Mm-hmm.
Who could be liable for that is the bank immediately. They're going to have to get back to them like, this person don't know what payment is.
Mm-hmm.
Different action can be taken based on ordinary care. Ordinary care is a way to show good faith. This goes back to Article 1 in transactions. In transactions, there should be ordinary care. Any action like them sending you a package that was handled wrong, that constitutes, ordinary care, because they still sent you a package, but the contents inside it said it was a problem or a mistake. It was some error. They was telling you of other locations held out. They was telling you something.
Yeah.
How you feeling? You with me?
Yeah, no, I am.
So variation by agreement, measure of damages, and action constituting ordinary care. The effect of the provisions of this article, it may vary by agreement. So the agreements that you sign, they have their own provisions. This article itself is a provision. Do you understand?
Yeah, I could see that. I'm just taking time here to try to take that question in.
You have an agreement that you signed, and
Mm-hmm.
it's full of provisions, full of them.
Well, yeah, absolutely.
This article right here, Article 4-103, this is an additional provision right here.
Right, because, yeah, absolutely. Because everything is already subject to this article.
And it can help change.
Yeah, circumstance. Yeah.
Whatever you have, it has no effect on them yet. It just exists, but it has no effect. This article in 4-103 is a provision that could be applied to help change the agreement.
Mm-hmm.
But the parties to the agreement cannot disclaim a bank's responsibility for its lack of good faith.
Right.
So whenever you receive by agreement and according to a provision of statement, it's going to be showing you that a bank is responsible for lack of good faith, because there's going to be some things that's disclaimed. And by the agreement, the UCC can be disclaimed. The bank has responsibilities, and it's to fulfill other provisions. So whatever other provision is left that they're detailing on the back, that provision under ordinary care has to be taken care of in good faith. They always have. But any failure to exercise that right, or if it is disclaimed by you, then that provision is going to be exactly how it is. That's why they slapped that but right there. Yeah. They're telling you what they would like versus what may happen. There may be a failure to exercise ordinary care. And a lot of people don't know nothing about good faith. I have to go back to Article 1. A lot of people don't know about, who is responsible. They feel responsible.
Right.
So it's a failure to exercise ordinary care. And it's not only just on them, but it's also on the banks. Those who are responsible under state and federal law, those who are responsible who just engaged in that business by an agreement, they failed to exercise ordinary care, or they was limited.
Right.
So this is where the limit of the measure of damages for the lack of failure. They can't do what the bank has failed to do. If another lacks good faith, then the bank has to be the one to exercise ordinary care and lift those limitations and make claims. Do things according to the parties' agreement. Otherwise, it's going to be done a little bit different as it relates to that agreement. That the banks are responsible. However, the parties may determine by agreement the standards by which the bank's responsibilities is to be measured, if those standards are not manifestly unreasonable. So whenever you respond, you're setting a standard, different standard. Now that they have some writing for an individual, this standard is one of a Federal Reserve one now. And for as long as you're measuring and reviewing and determining and concerned with solving a conflict as it relates to the amounts and the balances, then it's reasonable for the parties to determine that there may have been some lack of good faith as it relates to amounts that's left open, or fees that isn't added, or interest that is not yet included. Things that will be manifestly reasonable more so at a present time.
Yeah.
Where rights can be determined. It's always going to be determined by that agreement. The agreement provisions, half are always going to be done at one time, and then another half is always going to be done at another time to fulfill the terms of the contract. That's just how it has to go. It's according to different standards. The state can do this, and they're dealing with remittances, but then you have the feds who's doing this, and they're dealing with transfers. It's different.
Yeah.
How you feel? Any questions before I go on to me?
No, it's all making sense, and reasonable commercial standards, like where it's a commercial transaction and it has to be buy, sell, trade. So buy and sell it's not enough. It's gotta be the whole package.
Sure do. And that's
And I just remember Shauna saying in Article 4, she's like, the individual is the only one who can care about ordinary care. And I think about that a lot.
Because we're the only one there.
Yeah, we're the only, exactly.
Like in reality, we are the only ones there. And besides the other individuals who we contact, otherwise it's just us. And at that time, we determine and we exercise and we move a certain way. And the way that we should move is always in good faith. Whenever there's a lack of good faith, it's due to things that have been disclaimed, things that have been discarded, disposed of, things that have been accepted.
Yeah.
Causing for, an item to exist but not have an effect. Federal Reserve regulations, though, and operating circulars, clearinghouse rules, and alike, they have the effect of agreements under subsection A. So whenever things exist and don't have an effect because the exercise of ordinary care haven't been there and good faith need to be applied, it's due to regulations not being applied, operating circulars and clearinghouse rules not being applied. It's
so they're really saying that, no matter which agreement or contract that you've involved yourself in, you might as well just apply this as well because it's there. It's always there.
Whether or not specifically assented or agreed to by all parties interested in the item that's handled. Yes.
Yeah, for sure. Absolutely.
It goes back to notice and knowledge where they talk about whether or not, whether you know it or not. Specifically, you can agree to other parties that are interested in the items and the agreements that they have as it relates to clearinghouse rules, operating circulars, and Federal Reserve. But these are things that are according to law. It's not legal business.
Yeah, no. Well, that's kind of like they cover their ass just by saying something very, very brief like federal law.
Yeah, or regulation.
It's governed by federal law and the law of the state of whatever.
Or they'll say rules.
Right. Yeah.
They automatically say agreement. They say agree. They might
unless prohibited by rule of law or something. What did they say? I was reading one the other day. Yeah, unless prohibited by rule of law.
Yeah, it's always in the section where they letting you know that they don't want to enter into any unlawful transactions because lawfully, look what they could apply. Look who they could be doing. Look who could measure that amount that's missing.
Yeah.
Without them, they cannot set that standard because their standard is based on other provisions of your agreement, and that lacks a little bit of good faith as it relates to the bank's responsibility, so they can't deal with it. They have to deal with another foreign. There has to be something else that constitutes the exact same thing. It's not the same, but it's so similar. Or I can take the beginning manufacturing of it and create something else, which is a
Yeah.
banking function.
Yeah, and I don't mean to let my mind always go to Article 9, but because there's this involvement of a security interest from the jump, then reasonable commercial standards will have to be addressing those filings. And so that's just kind of something that I see that
And that's
without.
what, and that's why they use that article for secure transactions. They do that, not us.
Mhm. Nope, no.
So see, they're actually talking about this action now. So action or non-action that the bank is liable for and has responsibilities for is approved by this article, Article 4, or is pursuant to the Federal Reserve regulations. So, as it relates to action, it can either be according to this article where things may have been approved and agreed to, like payment prior to, and then where things can be approved to a little bit later as it relates to Federal Reserve and, other operating circulars. These are things that can happen from time to time as it relates to action. But if not action happens, then of course it's not going to be any type of regulations being applied or operating circulars where they are exercising the ordinary care as it relates to the bank's responsibility. They're not the bank. So they don't
Nope.
have to do any of that. And in the absence of special instructions from somebody like you who can help instruct and add any of these persons who may be absent, who could actually take ordinary care. We're
Hmm.
waiting for you to take action and let them know about another who hadn't took action yet, but their action is consistent with clearinghouse rules and they can get a check or a like, whatever you would like. It's a part of a general banking usage. And anytime you sign an agreement and they talk about usage of an account or usage of a card, it needs to be approved. That is the action of a bank. So if that bank or that particular bank isn't the one who has in their possession, then it's going to be disapproved by this article.
Hmm.
If you have that prima facie evidence and you exercise the ordinary care, then this article will indeed be applied. In general, they hope that it is implied, and it will be applied. It will be applied similarly to get you that statement, but as it relates to clearinghouse rules, it won't be applied just yet until regulations is applied, and then once it's applied, it can be consistent with ordinary care, and they can get things that are similar, like a check or like that payment you receive. They'll get a different type of presentment, a different type of item
Yeah.
that has specifications. So whether it's that check, that money order, whatever it is that they asking for in an agreement, that has to be approved of by a bank. And there are certain procedures that this article needs to be applied. And the bank is the only one who can do that.
Yeah.
This article does not disapprove other procedures that may be reasonable under the circumstance where you signed an agreement and said that you're going to get this statement every month. You see what I'm saying?
Yes.
You said you're gonna get that. So cool, you're gonna get that. This article not disapproving of that. It's not disclaiming that. But there are certain procedures for a certain transaction where they can get the approval of a bank for specification as a way of using that prima facie evidence that was handled incorrectly by being presented to you, and they're able to create something like it, something different, like that check or whatever is agreed to as it relates to another in their business. Bank. They're going to be
Hmm.
to measure the damage for not doing it or doing so. So if it's action, they're going to measure the damage. If it's not action, they still going to measure the damage. And if it's not action, they already did. The damage is measured as to be a minimum payment or the full balance. If it is
Right.
action, then the measure will be something a little bit different. It'll be of a certain amount based on another procedure that is approved of. And that's under a circumstance where the facts are bargained. If not, then it's going to be a failure to exercise ordinary care in handling that item. And that amount is not going to be set. The amount of the item is going to be reduced by an amount. That means it's going to be out of it. And any amount that you have is going to be reduced. It could
Yeah.
have been realized by the exercise of ordinary care and they could have increased it. So when you get your payment, they tell you all of that. They tell you that the amount that's there that needs to be set need to be realized by a bank because it's their responsibility. They are the ones who are liable for ordinary care and any actions. And tell us. So for that, they can't set an amount. So the amount is always left open. If there is also bad faith, it includes any other damages that the party suffered as the proximate consequence. A lot of people like to ask me, can they get their money back from the things that they paid? Did you suffer from paying it? Did it hurt your pockets? Say something. And because of that bad faith and because of them collecting it, then when they exercise ordinary care, they realize it and they'll give you that amount back. It's not I'm trying to get over. If they investigate and they look into it and there's any sense of bad faith, then they will fix it. If you don't care about ordinary faith or realize that there is bad faith and they didn't take ordinary care and that amount is missing and it's a consequence, you're going to end up paying. So this is where they're able to approve of it not happening as well. It's a consequence for you having failure to be under a circumstance and act reasonable as it relates to what was provided to you, what was specified and what wasn't.
How does due diligence and ordinary care differ in your mind, in your opinion?
Due diligence to me is more so in the mix, because due diligence is what's going to get this transaction to me started.
Okay.
Good faith about it is what's going to allow for them to be involved, because they are the ones who are lacking good faith. They're missing it. So me having a good attitude about it and having due diligence to examine and review and look at the documents and let the person know just so that it helps the organization, that's me mixing both of the worlds, where I'm having ordinary care and good faith and due diligence.
Okay. Okay, cool. Because that's okay, cool. Yeah. That's a good, okay, I can feel that. It's almost like we can provide due diligence because it's, in Article 1, like if they had provide if they had exercised due diligence because they didn't.
Right. So I
But
have
we can,
due diligence. I mean,
and
I
then
get
you can,
that.
yeah,
I know
exactly.
something's wrong.
Right.
I'm reviewing it and I'm like, it could be another type of assessment I see because credit is involved. That's ordinary care.
Yeah, right. Right.
Me
Okay.
speaking up to the person about it so that they can contact any merchant involved because there may be a lack of good faith. That's good faith. That's me
Hmm.
speaking up and not failing to do so that other things could be approved of. Because at one point in time, this was approved of and it didn't cost for any type of action. But at
Yeah.
another time, you're going to get something and that's going to cost for some action.
Yeah.
Unless you want to pay and take that action. Like literally, that means you're doing the FRN thing or you giving a check. That's taking the actual action. Like, okay.
Yeah. Because they were working off a basic assumption
Yes.
based on our prior performance of how we wanted to handle this item.
Exactly. And more importantly, but how you're handling it presently, because they always let you know by agreement at any time. Anytime you discover this, you may
Mm.
change. If your account
Yeah.
was closed and you got a balance at any time and it's still default on account at any time, hit me up. A lot of people like to ask me that too. What if my account closed? What if it's default? What does it matter? Is it a balance on it? That means somebody ain't get something. You
Hmm.
gotta check, you gotta balance this with checks. It's checks and balances. Still,
Hmm.
regardless, nothing is changing it. There's things that need to be realized. And it's as it relates to the amount, the full amount, the entire amount. And that's something that the banks are responsible for. But because you sign that agreement and by that agreement, you pick up that responsibility as well. And whenever you do get your statements, they always talk about responsibilities and responsible persons. They mention financial institutions, they mention institutions, they say banks. They talk about those who are, responsible for these different functions. And then they go into detail about the functions that they actually would like electronic fund transfers. They don't just say, that this bank is like one responsible for some other stuff, but they throw their stuff in there too so that they can get payment.
It's crazy. What I've really realized is like the just how integral the default section of the agreement, any agreement is,
Mm-hmm.
because they are almost 100% of the time they either use obligation or secure or insecure, speaking to security,
Yeah.
or um or debt
And
or
then you got,
amount.
and then you got the whole assignment section. So
Yeah,
that's the
that's cold
consequence.
too. Yeah. Oh my God. Like, yeah, those two. Yeah.
It's a consequence. And if that assignment is not complete, There will be consequences, and the consequence is that there will be no action. No action
Right.
taken for damages, because there is conflict. Somebody literally sent you something and on the back told you it's a problem. Now, see, you see this stuff missing. That's crazy. And it's due to regulations. It's due to
It's
law.
like it comes in default, and because of that, it can't be assigned.
Yeah, because you have a payment without an extension of credit. The agreement that you signed was for future credits, regardless of the amount being needed. The agreement that you signed was for future credits. Now, the contract may have, related to an amount so that the bank can do what they're responsible to, but that agreement was talking about you being responsible for something different. So they're like, hey, when you
Yep.
get it, say something. Say something that's like what I said so that other rules can apply and the exercise of ordinary care can happen by a bank. And this is why we have after Article 4A, Article 5, which is letters of credit.
Mhm. Yeah, Article 4 is one of those articles where, like, as I get into it and I listening to it and reading it, I feel so good at the beginning, and then by the end, my brain is mush because that payer bank, depository bank, and that depository bank could be the payer bank and the intermediary bank, and I'm just like, oh my God.
So that's basically letting you know don't worry about who the bank is if you ain't the
Right.
bank.
Right. That's usually where I end up. I'm just like, okay,
Yeah,
thank God I
basically.
don't, thank God I don't need to do any of that.
Just know that a bank is involved and in their interbanking and in their banking functions, there's other banks, those who partake in collections, those who partake in deposits, those who, engage in medium of exchanges that are just different with different forms in different ways.
Yeah, like I said, I think that ordinary care, well, just kind of the earlier sections of Article 4, they let you know kind of what needs to be known, I feel like, and then it all gets into the action and shit, but it's not really our realms.
So that's when it just be like, do you stop reading or do you keep going? It depends on what you have took in prior to. It depends on if you feel out of it. Because as you go on, you're gonna want to feel in it because it's gonna sound so good to you.
Yeah.
But it ain't for you.
Yeah.
So what this article applies to, how it applies differently, how it's used for ordinary care, how it's used to measure damages, how it's used to by those of state levels and federal levels versus the standards and the bank's responsibilities, what each of them believe and interpret it is different. State rules, federal rules is different. Their interpretation is different. Their standards is different. So these provisions, they help to make effect things that have no effect, but conspicuously is being implied. We hope
Hmm.
that you, as someone who isn't a limited being, do actually exercise or make any type of movement or any type of transaction where you are, having ordinary care by speaking up and saying something so that good faith could be applied because it's lacking. Lacking for, as it relates to the bank's responsibilities for this next level.
Hmm.
Not
Yeah,
necessarily
definitely.
the state. And for as long as it's under state, then, it's good. It's covered.
Yeah, they sure didn't have any problem with it when they used the benefit of that federal person in the application process.
Right, that first time.
It's so crazy. It's just like we just dropped out. Everybody
this
just
is
drops
when
out.
this is when it's important for you to understand that they all dropped out because you pre-authorized something.
Yeah, I can see that.
From that point forward, until they are contacted or notified, then it's no action that they can take further. You are the
Mhm.
applicant at that time who will be an authorized representative later, so roles can switch. And if
Yeah.
they are contacted by someone in either capacity, then doing things that constitutes what an applicant would do or constitutes what an authorized representative would do, then they can't constitute any other type of action that relates to ordinary care or banking. Period.
Somebody the other day, I don't mean to go off topic, but somebody the other day in my world, they were bitching about something about Social Security benefits, and they're crying and whining about when the benefits that they pay into, and I'm like, have you ever tried to open a bank account without your social security number? Like, what benefits do you think you have? Like, benefits is like using the damn number, like to do everything you have to do.
Right, that's the point.
Like,
That's
come on. Like, does nobody ever think
that's
about this
you
shit?
exactly because that's using the system, and they don't think they use the system. But yeah, you are like you signing an agreement that formed the contract that you using the system. It
God damn.
constitutes it. So I'm gonna go ahead and stop it here today, and we'll pick up. I'm gonna take you on a little bit further, and whenever you're ready, just let me know, and we'll meet up.
All right, sounds good.
All right, peace.